Good afternoon, everybody, and welcome to this One Chancery Lane webinar, which is a second part, as it were. Some of you were lucky enough to join David and I at the end of last year for the first webinar on limitation, where we dealt in some detail with date of knowledge and what that means in the context of limitation, wanting to properly understand the applicable law in that area and how you as solicitors working in the best interests of your clients can get a handle on the law and use it to their best purposes. So today we're going to deliver part 2 of our webinar. The focus is going to be overwhelmingly on section 33, and David is going to take you through a lot of that. But first, I am going to give you a brief recap on section 14 and date of knowledge issues, because of course without understanding that basis it's going to be very difficult for you to get a proper handle on the section 33 aspects. So starting with date of knowledge, most of you are aware that the law in this comes from section 14 of the Limitation Act. I've put the relevant subsections there on the slide, and before anybody asks, please don't worry, we are going to circulate these slides to you all after the webinar so that you'll be able to go back and have a look at them. There's a lot of information included in these particular sets of slides, and also you'll see that I think there are 47 of them, so please don't worry, don't panic. You're going to have a chance to consider them in your own time. So, back to basics. Section 14 of the Limitation Act. Subject to subsections 1A and 1B below, in sections 11 and 12 of this Act, references to a person's date of knowledge are references to the date on which he first had knowledge of the following facts. When considering 1A and 1B, I've set it out there briefly, but I'm not going to spend very much time on that now. We discussed it in some detail in the last webinar. Next slide, please. The leading judgment on date of knowledge remains that of the House of Lords in Hayward and Fawcett's. Although quite an old decision now, 2006, that was a really important judgment in consideration of the meaning and applicability of section 14 of the 1980 Act. That claim concerned financial advice rather than medical services, but the clear articulation of the relevant principles are of equal application no matter what kind of case you're dealing with. So for those of you who have quite a broad practice, or perhaps if you're relatively junior and seeing quite a lot of different types of work, limitation works across the board, and being able to understand how date of knowledge works will assist you no matter what it is that you are dealing with. So in the Hayward case, the court examined the degree of knowledge required for time to start running under section 14 and the degree of certainty that a party must possess. Next slide, please. So where are we on date of knowledge? It's the date on which the person first had knowledge that the injury in question was significant, that the injury was attributable in whole or in part to the act or omission which is alleged to constitute negligence, and the identity of the defendant. It's actual knowledge. If the negligent was that of a person other than the defendant, the person has knowledge of the identity of that person and the additional facts supporting the bringing of an action against the defendant. For example, the tortfeasor was an employee of the defendant. Of course, these questions are absolutely central in clinical negligence claims where there are non-delegable duties, and in any case where you might be considering whether there might be a relationship of, for example, vicarious liability. But more commonly, this is just a straightforward, we allege negligence on the part of X, he was employed by Y NHS Trust or Y Health Authority. Note that knowledge that any acts or omissions did or did not as a matter of law involve negligence is irrelevant. So you just have to know who it is you're suing and have the facts to support that. Next slide, please. Whether an injury is significant is subjective, of course. Section 14.2 develops this. If the person whose date of knowledge is in question would reasonably have considered it sufficiently serious to justify his instituting proceedings. Section 14.3 is more objective, so a person's knowledge includes knowledge which he might reasonably have been expected to acquire from facts observable or ascertainable by him with the help of medical or other expert evidence. This is really important too, and I spoke at some length about this in the last limitation webinar, which, by the way, is on YouTube. So for any of you who have only tuned in to this webinar and you wish to watch the first one, it is available on the One Chancery Lane website. But going back to the section 14.3 objective test, this is the sort of question that quite frequently comes up, which is where in the medical records there may be a note of a consultation between a GP and a patient in which issues were discussed which may or may not be relevant to the significant injury that is then complained of as a result of a claim or the promise of litigation. And the defendant says, well, you knew full well at that point, at that discussion with the GP, that something had gone wrong. And that is both a subjective and an objective facet of the litigation, and it will need to be explored and perhaps supported by witness evidence, because sometimes you do have a discussion, but the implications of the discussion are not understood. Or I'm just thinking of situations that I have seen in my own work where the defendant points to a note or a letter and they say, well, you ought to have realised at this point that there was an issue. Why didn't you bring your claim earlier? And the claimant sometimes has a very plausible explanation for that. So don't be afraid if there's an argument about this, but do make sure that you have enough factual evidence from your witnesses, from your claimant, from the medical records that you think you can justify a dispute as to the date of knowledge. Next slide, please, David. Some of you will recall the decision in Balls and Reeve. I'm going back to it because it's a recent decision and I think it's really helpful. In that case, the claimant had worked with asbestos for 5 years to 1984. He developed asbestosis and symptoms in 2016. He was diagnosed in 2017. So, of course, a long time after the exposure. He had, however, suffered from mild respiratory problems over many years. And the claim was against the former employer who had caused him to work with the asbestos. The defendant asserted the action was time barred, and the court did not find it appropriate to find that the claimant was fixed with constructive knowledge under section 14 because of the respiratory illness prior to 1916, skipping 100 years there, 2016 was mild and insidious. So that's an illustration of exactly that factual and legal matrix that I was talking about just before. It's where there has definitely been knowledge of something, but you can't pin it down. It's not what we would describe as constructive knowledge, and it's not what the court, more importantly, would describe as constructive knowledge, and not what David Pittaway QC, sitting as a judge in Balls and Reeve, considered to be constructive knowledge. He went on to say, to talk about limitation, actual knowledge. The claimant did not have actual knowledge within the meaning of section 14 of significant injury attributable to his exposure to asbestos between 1979 and 1984 until he was diagnosed with asbestosis in 2017. So there, of course, it's vital to recognise the causal link between the asbestos on the one hand, the exposure, and the diagnosis with an illness which was directly and concretely linked to that exposure. Although he accepted that he had suffered from respiratory problems for some years, he clearly considered that they were not sufficiently serious to bring them to the attention of his GP or doctors at hospital appointments until early 2017. He had received a copy of a hospital letter of 2013 following his x-ray, but had not regarded its reference to exposure to asbestos as being asbestosis. So you see how narrow and finely balanced these considerations have to be. Constructive knowledge, on balance, the claimant should not be fixed with constructive knowledge within section 14 that his injury was significant prior to the diagnosis of asbestosis in 2017. His date of knowledge was in 2017. The claim was not time barred and it could proceed to trial. Next slide, please, David. Moving on then to the discretion under section 33, that is really going to be the meat of today's webinar. I'm going to hand over to David in a minute, but I thought it is important for everyone to understand the context, the way in which Section 14 and Section 33 interact and respond to each other. So when there is an argument about date of knowledge and the defendant knocks or thinks it's knocked the claim out because they think they've got a good case on date of knowledge, the claimant will almost certainly cross-apply for permission to extend the applicable time limit under Section 33. So this was, I think, an important facet of the decision in Balls and Reeve as well, where the judge went on to say, even if the court's conclusion as to the claimant's date of knowledge was wrong, it would have exercised its discretion under Section 33 to permit his claim to proceed. Having regard to the criteria of Section 33 and all of the circumstances of the case, it would be unjust to deprive the claimant of the opportunity to pursue a remedy. There was no serious prejudice to the defendants as a result of any delay in bringing the proceedings, and David will speak in a moment about the importance of being able to demonstrate prejudice, because in this case, clearly the judge felt there was no serious prejudice, but in other circumstances, I think it's going to be almost the strongest point that the defendant can make, that it is going to be severely prejudiced by the bringing of proceedings regarding an accident or actions that took place sometimes decades ago, as in an asbestosis case. The events took place a very long time ago, and even if the claimant had the requisite knowledge in 2004 as the defendants contended, the evidence available then would not have been very different to the evidence available now. Next slide, please. Very important decision. I think, David, would you like to discuss this one, or should I? I'm very happy to.
I think you just finish off this part of the Section 14, and I'll take it on later on and cross-refer to it on Section 33.
Fine. There was a slight debate about where this case should come in the slides before we went on, but I think it is important for it to be here. This was a case called Olyse Aderonmu. It was a decision in the Queen's Bench division by Master Cook, and it's recent. I think the facts, again, really clearly illustrate the importance of getting to grips with the interaction between Section 14 and Section 33. In November 2009, the claimant had a consultation with a GP who noticed that he had difficulty talking and that further tests were required. 4 days later, he suffered a stroke which caused a neurological injury. The claimant brought a clinical negligence claim against the GP for failing to refer him for urgent investigations for a possible stroke. In November 2011, the claimant applied for leave to remain in the UK. That application was refused. He appealed, and the immigration proceedings were not concluded until 2017. In 2017, he then contacted solicitors about a possible clinical negligence claim. Almost 8 years after the stroke, he issued proceedings alleging negligence by the defendant in failing to exclude a stroke and to refer him for investigations. The defendants raised a limitation defence. Next slide. The claimant claimed that the 3-year limitation period had not started to run since the date of the accrual of the cause of action. He had lacked capacity to conduct the litigation within the meaning of the Mental Capacity Act 2005. He was therefore to be considered to be under a disability for the purposes of the Limitation Act. And of course, all of you will be aware that if you're under a disability, or in the case of children, the Limitation Act gives you different time limits. He also advanced a secondary position. If he was found to have capacity, he did not have the requisite knowledge for the purposes of Section 14 from a date more than 3 years prior to the 2017 date at which he launched the claim. Alternatively, he sought the disapplication of the limitation period entirely, which is something that can be done by the court under Section 33. And although it's, I think, quite rare for a court to consider that that is an appropriate step, nonetheless, it is an important part of the matrix which you should always be considering if you are applying to set aside or extend a limitation period. We're going to come back to Aderonmu later in the webinar, or rather David is, but I'm going to move on to another decision which I think everyone should be aware of. That's the decision in Wilkins. Again, a recent decision with a really good, clear exposition of the importance of date of knowledge, the interplay between Section 11 and Section 14 of the Limitation Act. I've put a brilliant victory from Chambers' own Paul Stagg. Well, it was, and of course it's David and I delivering the webinar today, but the reason you've all tuned in is because we are, of course, masters of the art of advising on complicated limitation points. I'll stop now, don't worry, David's going red. This was a case where the claimant suffered from pain and swelling in 2009, suspected post-operative infection, delayed diagnosis and treatment. And there was, in fact, a trial of the preliminary issue of limitation. I'm just going to pause for a moment because quite often when limitation is raised as a defence by defendants, there is consideration of whether or not there is merit in asking for a split trial. Why is this important? It's important because split trials are often argued for on the basis that they will save costs. Because if you say, I've got a concrete limitation defence, and you're able to knock a claim out at a limitation trial early on, then of course you are precluded from obtaining loads of evidence, expert reports, so on and so forth, incurring huge amounts of cost in defending the claim. Similarly, for a claimant, if you're faced with a date of knowledge argument which a court considers to have legs, then again, you may save considerable time and cost by having that issue dealt with at the preliminary stage and not having to incur huge amounts of cost and time and effort in pursuing the claim all the way to a trial when there's a possibility that the whole claim might be knocked out at the very first stage by a successful argument on limitation. I have found that courts are quite slow to agree to split trials, and quite often, even though I've been asked to consider whether or not there's merit in asking for one, I found that it's sometimes an uphill struggle where, in actual fact, the cost of preparing for the trial on the preliminary issue is considered to be so great that the appropriate thing to do is to plead limitation in the defence. And then, of course, the arguments are usually rehearsed at JSMs, so on and so forth. And one would wish to bring all of that alternative dispute resolution forward, again, in order to save costs and to see if the limitation issue is such. And one can always make an application to the court for a split trial later on if one has to. Anyway, in this case, Wilkins, it was a split trial. It was a preliminary issue and limitation, and the argument was whether the claimant had knowledge. And what the court said is that he did not need to appreciate all of the details of the claim that he might later formulate against the defendant for time to begin. He was not required to show that there'd been an actionable breach. It was sufficient that he understood in general terms the essence of the factual case upon which a later claim might be based. Next slide, please. In a clinical negligence claim, it was not necessary that a claimant appreciated the precise mechanism by which he had sustained an injury. Sufficient if he had an understanding in broad terms that the lack of medical care might be a possible cause of injury. The details of the claim are on the slide. I'm not going to go into much detail. It's safe to say that the claimant in this case knew that his ongoing difficulties could be due to the substandard care by the defendant. This was broad knowledge for the purposes of Section 11. By 2012, he had the requisite knowledge, so the claim was brought at 7 years after the time began to run and 4 years after it was statute barred. The court then turned to the exercise of the Section 33 discretion to permit the claim to proceed and decided that it was equitable in all of the circumstances to disapply the time limit and to permit it to proceed. This is an important case for any of you who might be dealing with bodies of claims like, for example, vaginal mesh cases where date of knowledge is quite often brought up as being a really central plank of a defendant's response. But in actual fact, I think Wilkins is going to be essential in understanding the court's approach to how the limitation period works in relation to injuries which could be more described as subtle. So moving on quickly to brief conclusions on section 14, David Thomson is going to explain in more detail about the claimant's escape route in section 33. But it's really important to remember that the mix of objective and subjective knowledge required to form a date of knowledge is intrinsic to this whole exercise. For a claimant, you want early record of evidence on date of knowledge. Make your case in the letter of claim. Make sure that you have drafted a witness statement in support of any application that you want to make. Make sure that particulars of claim have accurate and consistent facts which deal square on with any argument about limitation. The response to it will be a pleading that your claim is statute barred. So look ahead, work out what the defendant might say, and then answer it. If you're not able to answer it, then you may want to think carefully about where you stand. Do not be complacent or passive. If you're a defendant, sorry, in the next slide, please, David. If you're a defendant, look early to whether a limitation case can realistically be made out. Does it have legs? Get across your evidence as quickly as possible. It's not really enough to traverse an eventual defence. You really need to be flagging this up in pre-action correspondence, otherwise courts will be cross. Look to the evidence from treating staff concerning actual and constructive knowledge. Get into those medical records as quickly as possible. If you find things in there and you think that there may be a good defence, there is no harm. David and I are constantly asked by solicitors who instruct us, what do we think of this? You can always send an email for a quick sense check. We're always advising on whether or not there might be a good defence, or whether or not, if you're for a claimant, there might be a good Section 33 application. These applications are well, I was about to say bread and butter. I'm not sure if they really are, but we certainly are very experienced in dealing with them. And then, if you're drafting a letter of response, make sure you focus it on date of knowledge if that's going to be your case. Sorry, the next slide is the third conclusions and tips slide. Be alert to time limits from the very beginning. Understand how the law works and what the interplay is. Look at the case law, particularly I think that recent case on Wilkins is really important and really helpful, and it should be instructive to you in formulating your case. We're going to move now on to section 33, and I'm going to hand over to David Thomson.
Excellent. Francesca, can you hear me? Is that clear?
Yes.
What a very good explanation of section 14. We took the view that the section 14 reminder had to be put in place because you can't really understand section 33 in isolation without getting the initial reminder about section 14. What I'm going to do is outline the Act, just to remind you how it's applied, look at some recent cases, and then our analysis of where we are, the points that claimants and defendants can focus upon and try to exploit. So here we go, section 33, discretionary exclusion of time limits for actions in respect of personal injury or death. You can see within all of this just a couple of things. They always mention plaintiffs, that's the way legislation is, now claimants, and just as a matter of naughtiness, I've changed a number of the he's to she's. The usual circumstance for a clin neg claim is that there's a clin neg protocol that may or may not be followed. It may be that the person doesn't issue a claim form in time and then serves the claim form and particulars, or maybe that's something that, as we've already flagged up in, there's something to do with asbestos exposure and it's happened many, many years ago. Often with the initial letter of claim or in the particulars, the defendant indicates the action is time barred and it shouldn't be brought because the limitation period has gone. And there may or may not be that traverse the defence, it very usually is, or there may be a reply from the claimant explaining why and the further details why it's not time barred. Francesca has already demonstrated that it's often a trial of preliminary issue and the mixed results for defendants makes part of the consideration of whether a TPI should be applied for or not, and also whether the judge making the directions will be minded to order a TPI and then the current circumstances and where the case law is. And specific provisions for other matters are just reminding people about armed forces overseas and other claims that have nothing to do with clinical negligence You can read this in your own time. Beware, though, about section 33.2. If there's a limitation because there's another cause of action under the example given here is the Carriage by Air Act, then the section of 33 isn't going to apply. So you've got to be live to this, that if they're brought under a separate act with its own time limits and provisions, then section 33 won't apply. I mean, obviously that's something that the claimants need to be aware of and defendants need to focus and exploit and point out as necessary. Section 33.3 sets out the matters that the court should have in its mind and apply the evidence and the consideration to. The point about the section 33 relief is that it's said again and again now that it's an unfettered discretion and it should be considered broadly. That's for the claimants to exploit. It's for defendants to understand the landscape, and the main emphasis for the defendants at present, and I'll detail this further, is about prejudice. Well, where's the prejudice, and is that prejudice convincing, certainly convincing for the court in the present landscape? The number of factors that are taken into account for section 33.3 are set out here. A, the length and the reasons for the delay on the part of the claimant. B, the extent to which, having looked at the delay or considering the delay, it's going to affect the evidence adduced either by the claimant or the defendant. So is it going to be less cogent? We'll see from the Musser case, that was the case that it was less cogent, in particular because the consultant gynecologist had died. The conduct of the defendant after the cause of action arose, responded to requests, which may or may not be relevant, but it is something that is taken into the consideration of the exercise of discretion. And then the duration of any disability of the claimant arising after the date of accrual of the cause of action. Now, this is an emphasis on after the date, so you've only had problems that have happened after this. It's nothing to do particularly with your pre-existing problems or disabilities unless that goes to capacity. The extent, the claimant acted promptly and reasonably once he or she knew that the act or omission to which the injury was attributable. It's a combination of knowing that there may or may not have been an act or omission or suspecting that, and that's the Wilkins point, to which the injury was attributable. So it's not just the fact that the act or omission, but it's got to be that the injuries were attributable and that it might be capable of giving rise to an action for damages. There doesn't have to be any detailed understanding of whether there was negligence as such. And then F, the steps taken by the claimant to obtain medical, legal, or other expert advice on the nature of that advice. Just to emphasise, the court's got a wide discretion. The civil procedure rules on relief from sanctions don't apply, so you can forget all the Denton aspects. However, in my view, the overriding objective is yet to be addressed fully, and that's to do with considerations of proportionality and cost in particular. It's something that has yet to have the right factual case to come up, perhaps for some trivial injury or something similar, about whether proportionality is going to come into play. We've seen recently the Ho and Adnecum cases, the effect of the interpretation of the rules on costs. I think it's only a matter of time before some case fully develops the overriding objective in limitation. Just a reminder, 33.3d about capacity. If you lose your capacity before the 3-year limitation period, so let's say you have somebody who's had a head injury and has subsequently poor orthopedic treatment on their leg or something, and with that head injury you don't have capacity to manage your legal affairs or even understand what particularly is happening, then the limitation period isn't going to accrue. But the duration of a disability arising after the accrual of the cause of action is a relevant consideration. So if you have a bad injury to your leg and you subsequently are unfortunate enough to sustain a head injury a year later and you don't have capacity, the limitation period has crystallised and it will run because your capacity was good at the time but was destroyed afterwards. But it's obviously clearly going to be a relevant consideration in the exercise of the court's discretion under section 33. Emphasise court's discretion unfettered, requires a balance of prejudice. burden on the claimant to show the prejudice outweigh the prejudice suffered by the defendant, and the burden on the defendant is to show that evidence adduced or likely to be adduced will be less cogent because of the delay. From the defendant's point of view, this is the prejudice that they're going to suffer, and that's really what you have to focus upon from the defendants in this landscape. A number of decided cases, begin with the Mossa one that I just briefly mentioned, that here we are, it's transvaginal tape. Many of these cases have come to light. Private hospital, private patient of Mr. Musser, and there was an initial decision by Master Cook and then appeal before Yip. The point about the tape is it was eroding the vaginal wall, and there was that was noted earlier on, and then subsequently there was a lot of media about the transvaginal tapes, mostly not just to do with erosion, but to do with chronic pain. We've all been involved in a number of those. And what happens is that the claimant in that alleged that a date of knowledge wasn't until those sort of problems later on happened. The difficulty was that she'd been for treatment, for corrective treatment, a number of years earlier, and that the defendant said that she'd had knowledge years before she started bringing these proceedings. Therefore, Master Cook ordered a TPI on limitation. He found the date of knowledge was September, earlier than the later storm and cloud of information about TVTs and their problems. Looking at all the circumstances and balancing the prejudice to each, he said it would be equitable to allow the claimant to proceed, and he made a costs order on the TPI against the defendant. The estate appealed. Mrs. Justice Yip dismissed the appeal and concluded that Master Cook's judgment was sufficiently clear and thorough, and that weighed all the evidence and looked at the evidential gaps resulting from Mr. Musser's death before the conclusion. The point being that Mr. Musser had made contemporaneous notes, and that those notes included a consent form, that they were fairly rudimentary. He had gone on to die prior to the proceedings. I think he'd been served on his deathbed, as it were. I think he was very ill at home, and he was served at home. He never got to see the proceedings. His wife took the documentation to the private hospital to share with them, and that nobody was able to get any proof of evidence or further details from him. The thing that he emphasised was that whether it was still possible to have a fair trial of the issues on the available evidence, which is the written evidence of Mr. Musser, the clinical records, and the recollections of Mrs. Wise. Mrs. Justice Yip found that the estate had argued that the dialogue between the doctor and the patient, the consideration of that was the heart of the case, and that would be oral evidence from Wise. But the hospital, or the estate of Mrs. Musser, argued that this issue about being able to look at the oral evidence and the ability or inability to rely on it, and the discussion with the condition is likely to be very great importance. That seems to me to be, in one sense, self-evident, and that must be true in not just clinical negligence, but in almost every case. Clinical negligence is slightly unusual compared to a number of other cases because quite often there are contemporaneous clinical records. Many other common law cases don't necessarily have those sort of contemporaneous clinical records, for example, or consent forms. However, it must be true that the contemporaneous oral evidence or oral evidence to consider the contemporaneous records from the potential treating doctor or other member of staff that was allegedly negligent must be important. But in this particular case, the court decided that it's unlikely that he would have any detailed recollection of the claimant or dealings with her. And they brought up some evidence from Miss Davis, who was a colleague of Mr. Musser, saying that no independent recollection of Mrs. Wise. She'd seen the claimant at a consultation, but she couldn't recollect Mrs. Wise at all. And therefore, because she couldn't recognise or recollect the details of Mrs. Y's treatment, then it's not likely that Mr. Musser would. I have to say that this seems to me to be slightly tenuous, but it's an illustration of the court having to make a decision on the facts and the evidence that's before it. Again, there's mention of the consent form. One word to the wise here is that there was consideration of what the value of the consent form in this particular case and in general. And Mrs. Justice Yip emphasised that the duty on the medical professionals to keep a good record. And she concluded that it would be difficult for a doctor to allege that he had provided significant information by way of a dialogue which went well beyond what was recorded. Now, the point about that, sorry, I've just got the underlining and a bit mixed up, but this is the point of it, is that Mrs. Justice Yip is expressing what is sometimes not really articulated, that it's difficult oral evidence from a healthcare professional, given subsequently a number of years later, to add to or detract from what was the contemporaneous written record, in particular the consent form. Often in the consent form, the explanation is a duality of what the procedure is intended to be and the complications thereof, seen through the lens of Montgomery. So Mrs. Justice Yip is emphasising it's all about the accurate clinical records that must be full and accurate, and difficult for the doctor subsequently to allege that something else was said or discussed. So most is a taster of the case law, and the case law goes on to went back to the important case of Carroll and the Chief Constable of Manchester, and this is about a police officer who alleges that because of his training to become an undercover drugs officer, he became dependent on heroin. And then that was emphasised and accentuated by his sort of active service in that particular area, where he was doing test purchases and other such things, trying to get evidence and trap major drug dealers. What happened in that is that the court took the opportunity, and it's actually in paragraph 42, and I've set it out here, to summarise the applications and the case law that's relevant to the different facets of section 33.3. And I'll just go through these because I think it's worth emphasising them. Section 33 is not confined to a residual class of cases. It's unfettered and requires the judge to look at the matter broadly. That's the emphasis about the wide unfettered discretion. The matters in section 33.3 are not intended to place a fetter on the discretion given by 33.1. So it's making plain that the matters set out from A to F in section 33.3, they are relevant matters, but they're not the whole story. And in a particular case, there may be other matters in all the circumstances that can be taken into account. It's about the proper exercise of judicial discretion, and the test is a balance of prejudice between the claimant and the defendant. The claimant has the burden to show that his or her prejudice would outweigh that to the defendant. So it's almost a competitive exercise. And that, again, coming back to the refusal to exercise discretion or deny a claimant a right of action or a claim to continue when he or she may have suffered significant injury. What it will do is, if it is exercised in the claimant's favour, the defendant will have to continue to meet and address the claim and the substance of its merits. The burden on the claimant is necessarily a heavy one. This is Carroll, which is, I think, 2018. Even in the last 3 years, even though it's been sort of slightly altered by the COVID and time has run rather fast, the matters have moved on. And I think in some respects that this reinforcement here, the burden on the claimant is necessarily a heavy one. It's now not perhaps as heavy as it might have been perceived a decade ago. Ultimately, the burden on the claimant to show it's inequitable to disapply the statute. The burden of showing that evidence adduced or likely to be adduced by the defendant is likely to be less cogent because the delay is on the defendant. So it's clear that the defendant has to show the prejudice and that the burden is on the defendant to demonstrate that. And that's usually to do with the efflux of time, people's recollections, Mr. Mosser dying, As you can see, though, even those sort of circumstances don't seem to succeed. If relevant documentation has been lost or destroyed, that's obviously a factor that may weigh against the defendant. That seems fair enough to say. It depends on the particular facts and circumstances. But it could well be that the documentation has been lost and destroyed because the proceeding is brought considering matters that were decades ago or many years ago. So it'll have to be decided on the particular facts and circumstances, and whether that loss was inadvertence, lost in a filing cupboard somewhere, can't be found, or whether it was a accidental matter, or maybe nobody knows. The prospects of fair trial are important. They're designed to protect the defendants from the injustice of having to fight stale claims. The difficulty with that is that to raise that up at the prospect of a fair trial, that's intimately related to the balance of prejudice, and in particular for the defendants with the efflux of time and matters such as poor clinical records, inability to recollect something that happened 12 years ago, and perhaps the fact that somebody may have died or been unwell. It's less likely that once healthcare professionals have died, but it's more likely that people have their own problems and aging and may well not recollect things for all sorts of good reasons, not just to do with time, but because they've had problems themselves. Looking at other matters, the defendant deserves to have the obligation to pay due damage removed if the passage of time has significantly diminished the opportunity to defend the claim on liability or amount. Caleb Francis will look at this in just a minute, but again, what we've got is we've got a situation where the initial principles are set out, but the discretion and the balance between the claimant's prejudice and the defendant's prejudice. But again, we're coming back to elements of defendant deserves to have the obligation to pay, considered very carefully. If the opportunity, because the passage of time is significantly diminished, the ability to defend the claim on liability or amount. So they're flagging up the fact that there are these problems, but we can see that they don't often necessarily get raised up. The period after the limitation period is important. That seems to me to be going without saying, that if the limitation period hasn't expired, then there wouldn't be such an assertion. But if the period of time after the 3 years, or whenever the 3 years after the date of knowledge, it is very significant, and that must be something that's more telling. And again, looking at the disappearance of evidence and the cogency of evidence. The reasons for the delay are relevant from the claimant, and that may affect the balancing exercise. I have to say that the reasons seem to me, from the number of cases I've dealt with, to be often very good reasons from a claimant's point of view. It's difficult often for a claimant not to have a good reason. I don't think I've seen a case where people have said, or the claimant has said, oh, I just couldn't be bothered, or I really can't provide you with a reason why I've delayed for the last 6 years. There's always some background reason, and most of the background reasons I've seen are cogent and do need consideration. Delay caused by the claimant's advisors from the claimant may be excusable in the context. We'll see this in Corbyn in a minute. This looks to the fact that in the past it used to be very significant that the problems with your solicitors, for example, or counsel acting, well, if they were the matters that led to a limitation problem, well, you could always bring proceedings against your lawyers. That's been, for want of a better word, de-emphasised, and now the consideration is that it's the claimant's case rather than saying that you have bring proceedings against your lawyers. It's been weighed into the Section 33 exercise discretion, and often it is a matter that allows the claimant to continue on with the case rather than sue their lawyers. Proportionality, this 12 material exercise discretion, the proportionality seems to be with regard to the modest financial claims that sometimes can be brought. It really doesn't fully develop proportionality in terms of the overriding objective with regard to costs and other such matters, not just for the sum that's being claimed. That hopefully will develop further in further cases. Appeal court are only going to interfere with the exercise of judge discretion where there has been a clear error of principle, taking into account the relevant matters or taking into account matters that are relevant. without giving them sufficient weight. That's just a reminder about the approach that the appeal courts will make. So, looking at what's happened, what's this profound list of integers from Carroll, how's that been put into place? Looking at the different cases, we've got Ellis, Blackpool, Adderonu, Bolton, Reeve and Wilkins. I'm just going to very briefly go through these because I see we're getting a bit short of time, and you can read most of these for yourself. Cerebral abscess, Ellis, and he went to his GP, neurological abnormalities, and went to Solihull Hospital. CT scan was done, showed an abscess or a tumour, discussed with the neurological team at QEH, requested further imaging and blood tests. What happens is that there is consideration of the case against D3, the GP. There's initial expert report that's not supportive of the claim, and the decision was taken by the claimant not to pursue the claim against the GP. Subsequently changed to his counsel lawyers who weren't satisfied with the GP expert evidence. Second opinion was sought, and that was critical of the GP, and therefore the claimant solicitors contacted the solicitors for the GP to alert them to the fact that a claim would be made. Proceedings commenced, and the defendant served the defence denying breach of duty and causation. McKenna heard the case sitting as a High Court judge, and what we get here is we get a number of integers set out by His Honour Judge McKenna. Consideration of Section 33, court and fettered discretion, emphasising that again. Issue had to be considered broadly, up to C to prove the prejudice outweighed that the defendant had been notified and aware of the matter before the expiry of the limitation period, i.e. should have got across the matter, got the information from the GP, looked at the allegations that may or may not have been raised. If there hadn't been any raised, should have presumably invited indications from the claimant what they were saying about the care from the GP and how it was deficient. They produced a detailed letter of response, previously agreed to extend limitation. The judge, McKenna, took that to indicate that there was essentially a lack of prejudice to D3 because they'd spent time preparing the potential case, and any subsequent passage of time wasn't very prejudicial. And there was no prejudice in allowing the claimant to proceed against D3. Lack of prejudice is very important. He goes on then to explain how he put that into place. No documentation had been lost, benefit of contemporaneous records, own recollection of consultation had been given to his lawyers, this is the GPs, and there was a short period of delay. He found that the claimant would clearly be prejudiced if the action wasn't allowed to proceed, and that weighing those up, the prejudice to the claimant was greater than the prejudice to the defendants. Another case, Blackpool Football Club. This is about a professional footballer or somebody who was not part of a professional football team. It's about a youth player who subsequently became a professional footballer, and that there was a volunteer talent scout, Mr. R, who essentially was organising tours, and in those tours abusing the people that were on the tour, in particular the youth player DSN. The claimant wasn't directly associated with Blackpool Football Club, and the finding that the allegation was that the club should have been vicariously liable. I presume at least the usual circumstance is that the abusing coach is not worth anything, whereas the football club is or will have insurers. There are not many football clubs that are profitable nowadays unless you're owned by a state, but Blackpool presumably had insurers for which they would be good for any damages. There was an appeal against the vicarious liability, and there was also an element of limitation. Going on to the facts and what happened, the limitation had expired in 1995. The proceedings were brought many years later. The abuser had died in 2005. Vicarious liability, the court concluded the relationship between the coach and the club was one akin to employment because he was dependent on the club as an employee, and it would have been, and the tour was as close to an official trip as made no difference. Club appealed, Court of Appeal allowed the issue of vicarious liability, saying that there wasn't a relationship of vicarious liability between the club and the youth coach. But they disagreed with the issue of limitation. What the Court of Appeal found is that, as far as limitation was concerned, that the conclusion wasn't. There was ample material from which Section 33, the judge could reasonably exercise discretion in favour of disapplying the limitation period. The difficulty with this is that if there is going to be claims against the coach, he was already dead, it wasn't worth anything, there was nothing left for that. Even if there was going to be any form of claim that wasn't time barred against the club, well, that was too late, because there was no vicarious liability and there was no course of action for that, but the Section 33 discretion would have been exercised. Back to the Order on New case, Master Cook and his exercise of Section 33. The clinical records were all available, and that the GP had an independent recollection. Therefore, all the circumstances balancing out, there was possible to have a fair trial and equitable allow the action to proceed. Balls and Reeve, much the same thing. Unjust to deprive the claimant of the opportunity to pursue a remedy, no serious prejudice. Although the events took place a long time ago, and the claimant, even if he had a requisite knowledge in 2004, as the defence contended, the evidence available then would not have been any different to the evidence now, so there's no prejudice. Back to Wilkins, same thing, same sort of analysis. Prejudice, the defendant adduced little concrete prejudice. The court decided that a fair trial of the dispute may remain not only possible, but unimpacted by the passage of time. The court accepted the seriousness of the underlying claim and its importance to the claimant. Therefore, the court decided it was equitable on all the circumstances to supply the time limit and permit the claim to proceed. This is, again, a focus on the cogency of evidence, and decided that it wasn't going not to be cogent. The trend in the more recent authorities is clear, to focus on the pragmatic assessment of whether a fair trial remains possible rather than a punitive approach to delay. Kane and Francis,
I'm so sorry to interrupt, David, because this is so interesting. But I am really conscious of the time and the fact that we're already seeing some people drop out because I think this is their lunch break. I'm just answering the question that's been put in the Q&A box by Emily McQuilkin. She says that it seems that the courts are pretty claimant friendly when it comes to exercising discretion. I think that she's got a point in that the examples that we've been looking at do demonstrate the fact that the courts are sympathetic to to what they think might be deserving claimants who might have a really good case and might have really suffered serious injury. But it's really important, Emily, I think, to bear in mind that there will always be a balancing exercise here. And there is a balance of prejudice, and the defendant's side is not ignored. And if you are able to really substantiate the prejudice that will be suffered by the defendant in having to defend itself against a claim that's brought really late, then I certainly have been able to get rid of claims that have merit, possibly, that are brought by deserving claimants because they're time barred. The same, if one thinks about this in the same context as those issues that we've all familiarised as, late service of the claim form, for example, completely different set of rules. But in those circumstances, again, a deserving claimant, a good claim, it can be knocked out on a procedural point. So I wouldn't lose heart over it, but I certainly agree with you that one should factor in the risks when you're thinking about trying to, for example, strike something out on purely on a limitation point. I think it's quite often the case that there should be more to it than just a very narrow point. Although equally, date of knowledge is obviously completely vital in all of those circumstances. Thanks. I'm sorry to interrupt you, David. I just wondered whether, since we have those conclusions to discuss briefly, I thought we'll get to that now. And of course, everything on the slides will be sent to you all, so you'll have a chance to read them. And then if you've got any questions at all, you can email either me or David, and I've put our email addresses in the chat box.
Yeah. just read the Kane and Francis and the point that basically efflux of time affecting the cogency of the evidence is not something that's really making a telling impact on the courts. Further conclusions we've set out here, we thought, well, what can defendants do because of the landscape at the moment? And that's why we set up these bullet points. Look early to see what limitation, get across the evidence early. So that means seeing the healthcare professionals looking at the records, as Francesca's already said, treating staff, actual and constructive knowledge, and get a detailed first proof. An attendance note that's not properly done that might come forward 3 or 4 years later with the run of proceedings won't be sufficient. There needs to be preparation for a strong early letter of response, focus on the data knowledge and the Section 33 aspects.
Can I be really cheeky and just say, obtain counsel's advice on it?
Yeah.
Because that's our job.
Yeah. And also, one thing that is coming through is procedural prejudice. Has there been problems? They haven't done things in time. Those matters weigh heavy. Now, I know that Denton doesn't apply, etc., but in some courts, being able to run it past the likes of Francesca or myself or whoever, exploiting any possible procedural prejudice is sometimes a strong suit. Finish it off. Bang. There we go. Travel law. This is a plug for Sarah Prager and Andrew Spencer. We're going to give a wonderful travel law State of the Nation on the 27th in a week's time.
Not to be missed.
The two of them are a great double act.
Possibly funnier than today's webinar.
Not to be funnier than this very dry but important subject.
Yeah, not to do ourselves down, but
no,
there may even be props next week. I don't know. I wouldn't want to promise anything.
But we have said, if anybody's got any particular questions, I know there were a couple of questions before. If any questions flow from what's been read today or heard today, then just email through and we'll deal with them, because that's all part of the package.
I can see someone has just asked a question, but Anne, can I ask you to email us, please? Because I think we're going to have to turn off. I can see it's already 2 minutes past 1.
Yeah, everybody's chomping for the bag of noodles or something like that.
Well, God, I don't know about you.
Yeah.
Bag of noodles?
Yeah, don't you like noodles at lunchtime? They're good.
Right, at that point, I feel a sensible juncture to wish you all a very good afternoon, and thank you very much for joining us today for this webinar. A recording of it will be available on YouTube in due course, and of course you can email us any questions. You will be sent the slides. Thank you very much again, and good afternoon.
Bye-bye.
Bye.